Hello, this is Matt on the Moon Lambo channel. Ripple just filed a whole bunch of stuff, including their summary judgment motion, under seal, so we don't get to see any of it. Well, not yet, at least. Though we did know that this was going to be happening, so I'm going to give you the specifics surrounding that. Also, the SEC v. LBRY case is ending imminently, very, very, very soon, and this will be highly consequential. It's going to be precedent-setting, even if not binding legally. Judges, of course, are going to look at cases similar to ones that will be brought to them in the future, and this will be impactful. It will, to some degree, even if not substantial. It could be substantial, I don't know. It's going to have some sort of impact on the SEC v. Ripple case. So what's going to happen in the SEC v. LBRY case? Well, I've got perspective from attorney Jeremy Hogan, as well as attorney John Deaton, and I'll tell you this, too. As we get out of the intro of this latest Moon Lambo Hot Jam, attorney Hogan says that this is going to be a gigantic week in crypto. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so just this afternoon, there's this tweet from attorney Jeremy Hogan, who of course runs the very popular YouTube channel Legal Briefs, and he said, "This is a huge week in crypto law. The Ripple summary judgment briefs will be filed today, although we won't see them until Monday, and a decision in the LBRY case is expected this week. These two things will affect the entire space for years to come." That's kind of an interesting way to think about it. It's so true. We're about to get information, a lot of information over the next week, having to do with LBRY, having to do with Ripple, and whatever happens here is going to be tremendously impactful for maybe all of time, frankly. Because sometimes when when precedents get set, I mean, how frequently do such precedents get rolled back or ignored in the future? Not frequently. So this is a big deal. Now, we did know that the summary judgment motions would be filed under seal. In fact, here's a tweet from James K. Filan, who is an XRP community member, and he is an attorney. And so shout out and credit to him. But on September 8th, he wrote the following. The parties have filed a joint proposal to govern sealing issues relating to the upcoming summary judgment motions to be filed in the case. And I don't want to read this whole thing. If you want to read it yourself, just hit pause here, you can check it out. But there are a couple points I wanted to highlight. And this was written, on behalf of, yes, the SEC, but also Ripple, all the defendants, Brad and Chris also. But this is written by Ripple's attorneys. And so they note here, on September 13th, that's today, of course, parties file all materials relating to summary judgment motions temporarily under seal, including briefs, Rule 56.1 statements, and supporting exhibits. And then there was this. If you go to the next page, you can see that September 19th, 2022 is another date that they highlighted. And the attorney wrote, parties file, and this is on September 19th, parties file public redacted versions of briefs in support of the summary judgment motions, making only those provisional redactions requested by the parties during the meet and confer. So I'm not 100% sure on what the purpose of filing everything under seal temporarily was. It may have just been so that you can get the process moving forward because it's in the judge's hands, and so it's most important that the judge has access to this. And then that gives time to make sure that a different version is then filed by the SEC and by Ripple, which will include limited redactions that were ultimately agreed upon. So my suspicion is it's nothing more complex than that, but we do know it's coming. So the fact that this ultimately was filed under seal today wasn't exactly a surprise. Now, on September 8th, attorney Jeremy Hogan retweeted that from attorney Filan, and he said, "Circle September 19th as the day we get to see most of the cards the parties are holding. Ripple v. SEC. The end game. It's getting me excited. I'm weird like that." And then in response to Jeremy Hogan's tweet from today, noting this is going to be a huge week in crypto law, somebody named Anthony wrote to attorney Hogan and said, "What is your call?" And Jeremy Hogan said the following. "I might make a call on the Ripple case after reading the briefs on Monday, or I might chicken out. Haven't decided yet." And this is a big deal because this is when pretty much all the cards are on the table, not literally all of them, But whatever comes out there, like we should have a tremendous glimpse into what's been going on behind the scenes for over a year and a half at this point, because it's going to all be out in the wild, other than of course limited redactions. So yeah, once you get to that point, it's going to become increasingly clear. If there's an obvious slant in favor of the SEC or Ripple. Now, given all the pretrial stuff, I will not be surprised if there's a tremendous slant in favor of Ripple and XRP holders in terms of likely outcomes. And then there was this from somebody named Futurism, wrote to Attorney Hogan and said, any predictions on the LBRY case? And Mr. Hogan did respond, and he said, I think the judge is going to split the baby. Exactly how? I don't know. Just wild speculation. Yeah, so I have a couple thoughts on this, and I don't pretend to know either what's going to happen. But given things that the judge has said in the LBRY case, he does seem to understand utility versus speculation, and he seems to think that's rather important. It's an important distinction from what I've seen from him. And so I'm wondering if he'll do what I would perceive to be the right thing, I'm suspecting, and just find that the LBC token, the LBRY credit token itself, just by the nature of existing, is not a security, but certain transactions in earlier days perhaps are. And that might end up being what happens in the SEC v. Ripple case too. So yeah, if you're talking about splitting the baby, that would make sense. We'll see if that happens though. And then there was also this. The official LBRY account on Twitter said, the judge is about to miss his own timeline in our case. Who does he think he is? A software engineer? And then somebody named JFA responded to that and wrote, I really think that the judge is finding this case to be far more complicated than he thought. As the judge said, this is a mixed motive case where some LBC owners are investors and others are users. SEC has typically not brought actions of this kind against, e.g., condo owners. And attorney John Deaton responded to that and wrote, and he references Jeremy Kauffman here, who is the founder of LBRY. He says, like Jeremy Kauffman said, he believes the judge feels uncomfortable being placed in this position. Him taking his time is a good sign to me, and that he is hopefully being careful with the words he chooses. It's a good sign compared to rushing a decision agreeing with the SEC. Exactly, and I certainly hope that is indeed the case, because again, this is going to be precedent setting. Even if not legally binding, it's going to have a tremendous impact for the entire space. Attorney Hogan responded to LBRY's tweet there as well, and he seems to share the same idea as Attorney Deaton there, and he said, when waiting for a jury to return a verdict, the longer it takes, usually the better for the defendant. I don't think that translates 100% to the LBRY case, except to suggest maybe a nuanced opinion which takes more thought and time rather than just yes or no. And then the LBRY also tweeted out this, and to me this is a tweet that perfectly highlights the absurdity of what's actually being argued in this case. LBRY Twitter account wrote, the SEC admitted that many, if not most, people buy LBC to use it. The SEC then said that if 999,999 people bought LBC to use it, and one person bought it as an investment, it would still be a security. Make no mistake, the SEC is out to destroy the free exchange of cryptocurrency. Yeah, that's exactly spot on. Think about it, 1 million people out there. If 1 million people bought LBC and just one was using it as an investment, nope, it's a security. That is just the most absurd damn thing. Try applying that to anything else that exists in life. Doesn't really work so well. Like baseball cards, for example. Beanie Babies. You pick it. That logic does not flow, but this is what the SEC is actually arguing because they're terrible monsters. And so here's a tweet from attorney James K. Filan from several hours ago, highlighting that Ripple just filed a bunch of stuff under seal, and he wrote the following. The Ripple defendants have filed under seal their motion for summary judgment, the memorandum of law in support of the motion for summary judgment, the Rule 56.1 statement, a declaration of Michael K. Kellogg, and 106 exhibits. On Monday, September 19th, 2022, the parties will file public redacted versions of the briefs in support of the summary judgment motions, making only those provisional redactions requested by the parties. So there you go. We just got to wait another 6 days, and we're going to have like the bulk of all information that we're ever going to have on that day. So that's a big one. I can only imagine, like, that's going to take a lot of time. I imagine it's going to be massive, right? I can't remember what the page limit was, but actually, I really can't off the top of my head. But that was agreed upon also. Expect them to use every damn page. So it's going to be massive. So although I'm excited and looking forward to it, man, that's going to be quite the chore combing through all of that and covering it on YouTube. But I really do look forward to it. I love covering this stuff. So that's pretty much where we're at right now. That's the latest update. Let me know what you all think in the comments section below. I miss you when I don't hear from you. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.